Good morning, all of you. Yes. There's a question that I can see. How is separation of power diluted in parliamentary form of government? Yes, how is separation of power diluted? Because, why is it diluted? Yes, as simple as that the executive is drawn from the legislature. Yes, so you find that under this theory of separation of power, we had studied that all three organs should be distinct from one another and they should have their own functions. Yes, but in case of parliamentary form of government, the executive is actually drawn from the legislature itself. So there is overlap of two important functions in a same group of individual जो minister है वो MP भी है. Yes, so that is the idea and that is how separation of power gets diluted in parliamentary form of government. Fine. Fine. In the last class we were discussing about federalism. Yes, the sixth feature we had discussed federalism and we have distinguished between federal form of government and unitary form of government. Fine. Now let us discuss the essential features of a federation. What are the essential features of a federation? Yes, we know in a federal form of government, the power is distributed between the center and the state, or the central government and the regional or local governments. And the source of power for both center and state is the constitution itself, and both have independence in their own sphere of operation. Okay. In case of unitary form of government, all the powers are concentrated in the central government, and the central government, if it wishes to, it can give away certain powers to the regional or the local government. Yes, so as to facilitate administrative convenience, है for the sake of administrative convenience, and at any time they can also take back those powers that they have given away to the local governments. Fine, so that is the idea. Now, what are the essential features of a federation? Yes. First and foremost, the essential feature is existence of dual government. डुअल पॉलिटी या डुअल गवर्नमेंट. ठीक है, तो यहाँ पे डुअल पॉलिटी या डुअल गवर्नमेंट मतलब दो गवर्नमेंट तो होनी चाहिए, सेंटर एंड स्टेट मिनिमम. यू कैन हैव अ थर्ड टीयर ऑल्सो, बट एटलीस्ट देयर शुड बी 2 tiers. यस, देन ठीक है, एक है, लेट मी राइट दिस, बाय कैमरलिज्म. बाय कैमरलिज्म का मतलब क्या है? फॉर एग्जाम्पल, द पार्लियामेंट is comprises two houses, the Lok Sabha and the Rajya Sabha. Yes, Lok Sabha is the house of people, and Rajya Sabha is the house of states. To represent the state at the national level, there is this incidence of bicameralism, है ना. राज्य सभा इसीलिए क्योंकि नेशनल लेवल पे कुछ legislations हो सकते हैं which would impact. There might be certain legislations made at the national level which might impact the states. Yes, so it is necessary to have the consent of states in those legislation. Therefore, there is Rajya Sabha, yes, which has an important role, or the house of the states, which has an important role as far as federation is concerned. What else? No, center is not strong in a federation. That is very much an Indian characteristic where we find a strong center. हाँ, सेपरेशन ऑफ पावर तो यूके में भी है. ऐसा थोड़ी ना है, हर सेपरेशन ऑफ पावर इज टू प्रिवेंट इमर्जेंस ऑफ डिक्टेटरशिप और टोटलिटेरियन गवर्नमेंट, है ना. See, let us logically go with it. Now, supposedly, uh, there is there is a piece of cake which has been brought at home. Yes, so you are there, and there you must have a sibling, you know, your cousin or a sibling. So you want to share that cake. Yes, now both of you would want, है ना, जब घर पे लेकर आए, your parents might have brought it and they've said okay, it has to be equally divided. Yes, but there will always be some contestation. Oh, he has taken the bigger share, she has taken the smaller share, something of that sort. Yes, so there has to be some rules made that this is how the division is going to take place. Yes, there has to be some rules of procedure laid down कि division ऐसा होगा, इस समय खाएंगे, इस समय नहीं खाएंगे. Yes, after dinner you will get the cake, not prior to that. There has to be some rules, है ना, that has to be documented, है ना. If there is rules which are said, there is only oral rules, it might create problems at times. Yes, because I might say that no, you did not tell me this. There is no proof that the rule has been equally conveyed to both these individuals. Yes, so there has to be a written book of rules. Yes, what does this mean? It requires written constitution, which is clarifying what is the source of power, how much power does center have, how much power does the state have, and it is very well documented. It is publicly promulgated as well as enforceable. Yes, these rules should be known to both, plus there should be someone who can enforce these rules. In case there is a violation of the rules, then Constitution में लिखा है, there is a rule book, है ना, there is, your parents have told you, okay, this is how it is to be done, and they've written it on a piece of paper and stuck on the refrigerator. This is how the division is to take place after dinner. ऐसे ऐसे division होगा, जिसने ज़्यादा खाना खाया होगा उसको. When you are small, these things happen. Yes, कि you will get maybe a little larger share. जो खाना अच्छे से नहीं खाएगा उसको थोड़ा कम मिलेगा. Yes, who does not eat well, maybe they'll not get as big a share. Now that rule has been made, but still then after the rule has been made, there is still a dispute. According to the rule, the division has not taken place. He has still taken a bigger share. He has gone beyond his share and eaten. Yes, so you need an adjudicator, an independent adjudicator जो बोलेगा कि नहीं ये सही है, ये गलत है, आपने गलत किया, चलो थोड़ा उसको भी उसके साथ शेयर करो. Yes, so that independent adjudicator कौन होगा? It will be the independent judiciary. अच्छा, अब रूल्स तो कॉन्स्टिट्यूशन में लिख दिए, पेरेंट्स ने बता दिए ये रूल्स और रूल्स, है ना, दे हैव बीन ऑल्सो made and stuck on the refrigerator. But it might so happen that somebody else might come, your grandparents might come and say, okay, fine, let me tweak the rules, है ना, let me say irrespective of how much you eat, both of you get equal share or whatever. They might want to tweak the rules. Yes, so that should not be permissible. एक बार rule जो बन गया तो वो तो बन गया, जो division है वो division है. Yes, so there should be rigidity of the constitution. The rule, it should not be easily, है ना, कि कोई भी घर में आया and tweak कर दे, ऐसा नहीं होना चाहिए. Your relatives walk in and say, okay, fine, I'll tweak the rules. So that should not really happen. Yes, so there has to be rigidity of the constitution. What else? Yes, rigidity of the constitution. We accept कि अब जो rules लिखे गए हैं, जो है ना, those are the final rules. Yes, we all accept that once the rules have been written, they are supreme. You cannot really violate these rules that have been written. What else? Any other feature? Yes? Yes? हाँ, authority is responsible to the judiciary का मतलब क्या है? देखो, जुडिशरी के प्रति नहीं, सब कोई कॉन्स्टिट्यूशन, सुप्रीमेसी ऑफ द कॉन्स्टिट्यूशन है. जुडिशरी तो एडजुडिकेटर है. इसका मतलब ये नहीं कि जब 3 ऑर्गन्स में जुडिशरी सुप्रीम, हम तो जुडिशियल सुप्रीमेसी की बात नहीं कर रहे हैं, हम तो कॉन्स्टिट्यूशनल सुप्रीमेसी की बात कर रहे हैं, है ना? समझ में आ रहा है? सो दैट इज द आइडिया कि ऐसा नहीं है कि कोई एक ऑर्गन ज्यादा इंपॉर्टेंट है और दूसरा ऑर्गन कम इंपॉर्टेंट है. Fine. In fact, these are the essential features as far as federation is concerned. First, there should be 2 governments to begin with, जिसके बीच में division of power होगा. Then there is this idea of bicameralism that we have brought in. Bicameralism मतलब national level legislature should be a bicameral body. है ना? इंडिया में there is essentially राज्यसभा and लोकसभा. State level पे bicameralism is not very essential, but national level पे essential है. Why? To get representation of the state at the national level. Yes. Then there has to be a set of, हमने कहा था division, source of power क्या है for both center and state? Constitution. It is essential that the है ना, and this constitution cannot be oral. Constitution cannot be partially written. Constitution cannot be unwritten. It should be written document, so that there is very clear terms of distribution of power. Yes, written constitution, rigidity of the constitution. Nobody should be able to come and just tweak the constitution. It should not be easy to alter the division of power. In fact, in yesterday's class, when we were talking about the amendment procedure, we said Indian constitution is a perfect blend of flexibility and rigidity. As far as rigidity is concerned, we talked about 2 ways. One, special majority requirement plus special majority and consent of 50% of the states in case the federal division of power is to be altered. So, rigid constitution. Yes, then you need supremacy of the constitution. The constitution ने जो division of power कह दिया वो वैसा ही रहेगा. Yes, and in case of a dispute still arising between center and state, there is a need for an independent adjudicator, which is independent judiciary. Yes, these are certain features which need to be fulfilled for a country to be called as a federation. Yes, without these features, it is difficult for any country to be called as a federal state or a federal form of government. Fine, write it down. Essential features of a federation. Point number 1, dual polity. Dual polity, put a hyphen, presence of national and regional government yes, bicameralism, yes. Write down the national legislature should comprise 2 houses, put a hyphen, 1 representative of the people, of the country, and the other 1 representative of the people of the country and the other representative representative of the states. Third is a written constitution. Fourth is, so we are adding one more point, division of power. Now this written constitution should also elucidate on the division of power. Yes. Next, supremacy of the constitution. Supremacy of the constitution. Next, rigidity of the constitution. Rigidity of the constitution. Last point, independent judiciary. Independent judiciary. Judiciary. Full stop. Fine. So these are certain essential features which need to be fulfilled for a country to be referred to as a federal form of a government or a federation. Fine. Now, however, you find that as far as you tell me one thing, that does India fulfill all these essential features of a federation? Yes. Do we have dual polity? Yes. Do we have bicameralism? Yes. Do we have a written constitution? Yes. Independent judiciary? Yes. Rigidity of the constitution? Yes. Supremacy of the constitution? Yes. So if all these essential features of a federation are fulfilled by India, is it right to call India a quasi-federal state? Yes, in yesterday's class, one of you was referring to quasi-federation. So you find that since India, one of the argument is, since India fulfills all the essential conditions of being a federal form of government, we cannot refer it, we cannot call it to being a quasi-federal or quasi-federation. Fine. Fine. Now, however, you find that as far as India is concerned, India is a federal form of government with unitary bias. Yes. Let us give evidences of it. What are the evidences? Yeah, examples of India being a federation with unitary bias. हमें unitary bias के examples बताने. ठीक है, एक है emergency provisions. Emergency provision क्या है? Basically, the constitution talks about 3 types of emergency. We'll not get into details of it now. And during proclamation of an emergency, the federal form of government is transformed into a unitary form of government. There is concentration of power happens in the center and the federal distribution of power gets suspended. ठीक है, तो जैसे ही national emergency अगर proclaim करे, तो you find that the federal distribution of power often gets suspended and this federal form of government transforms into a unitary form of government to meet extraordinary circumstances. Ordinary circumstances. Yes. So you find that constitution has certain emergency provisions. Yes. In the last class, emergency provision हमने कहाँ से लिया है? Yes, Government of India Act 1935. Yes. What else? हाँ? President rule तो emergency का ही है ना? Second type of emergency is president rule या state emergency. ठीक है? क्या? Prohibition of rights कब? हाँ? तो वो इमरजेंसी प्रोविजंस में ही आ गया है ना. कुछ कुछ तरह की इमरजेंसीज में ऐसा होता है, योर फंडामेंटल राइट्स कैन बी सस्पेंडेड. यस, तो वो वो इमरजेंसी प्रोविजन में ही है. डिसेंट्रलाइजेशन ऑफ पावर, इनफैक्ट वी कैनॉट, है ना, डिसेंट्रलाइजेशन कहीं ना कहीं तो फेडरेशन का ही है. डिस्ट्रीब्यूशन ऑफ पावर इज टेकिंग प्लेस, है ना. तो हम डिसेंट्रलाइजेशन यूज करते हैं ये शब्द with respect to the third tier of the government, local self government, है ना, PRIs, पंचायती राज एंड अर्बन लोकल बॉडीज के कंटेक्स्ट में. तो इनफैक्ट इससे तो हम ज्यादा फेडरल बन रहे हैं. ऑल इंडिया सर्विसेज, प्रेजेंस ऑफ ऑल इंडिया सर्विसेज. ऑल इंडिया सर्विसेज कौन से हैं, एग्जाम्पल बताना. IAS, IPS एंड इंडियन फॉरेस्ट सर्विस. ठीक है, तो यहां पे क्या होता है, इन सर्विसेज में यू आर अपॉइंटेड थ्रू एन एग्जाम कंडक्टेड बाय UPSC. यस, सो यू आर रिक्रूटेड बेस्ड ऑन एन एग्जामिनेशन बाय द सेंट्रल गवर्नमेंट. you are appointed by the central government, है ना. UPSC comes out with the list of the selected candidate, ना, फिर Ministry of Personnel comes into the picture. So anyways, you are recruited and appointed by the central government, but for the majority of your terms you would be serving under the state government. But state government does not have many disciplinary power against the IAS, IPS and IFS officers. Yes, so this is also an example where the state government have to bear. State governments actually do not like IAS, IPS and IFS officers much. They prefer their own state service से जो क्या है ना candidate select होते हैं, they prefer them because it seems like a central imposition on them. फिर देखो, सेंटर अकेले काम तो नहीं करता. जम्मू एंड कश्मीर में तो पहले तो स्टेट गवर्नमेंट ही थी. अरुणाचल प्रदेश में भी वी हैव अ स्टेट गवर्नमेंट. 1987 अरुणाचल प्रदेश बिकेम अ स्टेट फ्रॉम अ यूनियन टेरिटरी. तो अगर स्टेट है तो फेडरल डिविजन ऑफ पावर है. इनफैक्ट जम्मू एंड कश्मीर में ज्यादा पावर था स्टेट के पास, है ना. तो वो अलग तरह का फेडरलिज्म का ही एग्जाम्पल है, हम बाद में डिटेल में पढ़ेंगे. लेकिन अभी somebody said about governor, reservation of a bill for the president. Yeah, in fact the entire position of this governor who's expected, he is the constitutional head of the states, but he is appointed by the central government. Yes, so you find that जो उनका head of state है उसको center appoint कर रहा है. Yes, he is not elected. कोई indirect election कुछ नहीं है. He is directly appointed. And if you are appointed by someone, your allegiance will lie with that person, because the central government can remove also the governor. So you find that the governor's position has often been misused by the center. Yes, they want certain bills to be reserved. They'll tell the governor that you reserve this bill. Yes, they want president's rule to be imposed. They'll ask the governor to present a report saying that there is such a condition in the state, that the president's rule should be imposed in the state. So position of governor is very, very disputed. फाउंडेशन में आप इसके बारे में डिटेल में पढ़ोगे. ये अपने आप में एक बहुत अच्छा, एंड इट्स अ लॉन्ग डिस्कशन, अ क्लास और टू, है ना. वी डिस्कस द रोल ऑफ द कंट्रोवर्शियल पोजीशन एंड रोल ऑफ गवर्नर. फाइन. व्हाट एल्स? Sorry, residual power and concurrent list, both of them are talking about basically this division of power is, you find, in favor of center. Yes, I've already mentioned something known as the Schedule 7. The Schedule 7 comprises 3 lists. One is the union list, the other is the state list, and concurrent list. You find, as far as the union list, it lists those subjects on which the central government can make laws. And there are 100 subjects in the union list. The numbers have increased. है ना, over period of time. State list 61. The numbers have decreased over the period of time. So you find who, in terms of quantity, it is union list, and also the subjects covered under union list are said to be relatively more important or at national level, है ना, national context में या general context में इनके पास ज़्यादा power है. So you find that the division of power is tilted in favor of the center because more subjects and more important subjects are included under the union list. Next is something known as the concurrent list. Yes, as far as the concurrent list is concerned, you find that both center and state can legislate on these subjects. Yes, they can legislate on these subjects. But supposedly there is a conflict between the central law and the state law. In such a circumstance, the central law will prevail, will take precedence. Yes, in case of a conflict, the central law will prevail. So once again, there is more power with the center. And there is this idea known as the residuary power. Residuary power refers to the power to legislate on the subjects which are not mentioned under either union, state list or concurrent list. So any subject which has yet not been listed as part of these lists under Schedule 7, who will have the power to legislate on it? So in case of India, it is center. In case of US, which was the first federal form of government that the world saw, the residuary power lies in the states. Yes, so you find that the division of power in case of the Indian Federation is tilted in favor of the center. Fine, what else? अपॉइंटमेंट ऑफ जुडिशरी नहीं बोलेंगे, है ना. जुडिशरी का अपॉइंटमेंट बहुत कॉन्ट्रोवर्शियल है. यस, वी फाइंड कंसंट्रेशन ऑफ पावर इन द जुडिशरी इटसेल्फ, लेकिन अपॉइंटमेंट ऑफ जुडिशरी की बात नहीं करेंगे. यस, व्हाट शी सेज, सिंगल सिटीजनशिप. In case of India, you have single citizenship, unlike US, where there is dual citizenship. What else? Single constitution. Barring once the state of J&K, which had its own constitution, no other state in India has its own constitution. अभी आप पढ़ोगे नागालैंड के साथ, है ना, there is a group called NSCN, नागालैंड सोशलिस्ट काउंसिल ऑफ नागालैंड करके एक ग्रुप है NSCN, और वहाँ पे पीस डायलॉग चल रहा है सेंट्रल गवर्नमेंट एंड NSCN के बीच में. ठीक है. एंड नागालैंड पहले डिमांड करता था एस्टैब्लिशमेंट ऑफ ग्रेटर नागालैंड. दे वांटेड टू सेसीड फ्रॉम इंडिया एंड एस्टैब्लिश एन इंडिपेंडेंट कंट्री कॉल्ड ग्रेटर नागालैंड, bringing in parts from the other neighboring countries like Myanmar as well. Fine. However, now they are working towards peace. अब ये Greater Nagaland का movement has subsided substantially, and we are looking at a peaceful, है ना, peace in Nagaland, no conflict with the central government. And the peace process is stuck because they want an independent constitution and an independent flag, to which the central government is not agreeing. Fine. So under Indian constitution, we have single constitution except once for the state of J&K. ठीक है? Yes. बिल्कुल नहीं हो सकता. हम सेसेशनिज्म को नहीं एक्सेप्ट करते हैं. हमारा देखो, इंडिया इज अ वेरी वेरी डाइवर्स नेशन, and unlike other countries, we have been able to peacefully coexist while ensuring our territorial integrity. Now it is a matter of हमें सोचने की जरूरत है कि how come India has existed with territorial integrity intact. Yes, because जब इंडिया फॉर्म हुआ था, पहले तो ब्रिटिशर्स ने कहा इंडिया इज नॉट अ नेशन, It is nation in making, they used to say. Yes, they said it is not a nation, it comprises many nations. And they used to take a lot of pride that it is because of the British rule that these different people are held together under a single country. Yes, and they had predicted as soon as we give independence, India will disintegrate. Yes, in fact, foreign scholars had said that by 1960s, India would surely disintegrate. There is no chance that India would survive as a united, integrated nation and moving ahead in the decades. But India, to the surprise of many, has continued to survive as a single integrated nation. On the other hand, Pakistan, which said religion is the basis of nationhood, has partitioned. और अभी भी वहाँ पे बहुत सारे fault lines perceptible हैं, ठीक है. तो how come India has survived? One reason is that we accommodate the demand for autonomy. अगर कोई हमसे कहता है कि I want greater, है ना, my group of people want greater right to self-determination, I want greater autonomy in internal administration, we say fine, we are ready to have a dialogue, and if we find it reasonable, we will give you more autonomy, provided the negotiation takes place within the united framework of India and under the Indian Constitution. तो इस वजह से इंडिया ने क्या किया है, इंडिया ने जैसे बोडोलैंड में, है ना, वी हैव क्रिएटेड बोडोलैंड टेरिटोरियल, है ना, काउंसिल, है ना, यू हैव गिवन असम के स्टेट में अ सर्टेन रीजन हैज बीन गिवन ग्रेटर इंडिपेंडेंस. हमने इस तरह के बहुत सारे एक्सपेरिमेंट्स करे हैं, जैसे शेड्यूल 5 हम पढ़ेंगे, शेड्यूल 6 है जिसके थ्रू ट्राइबल एरियाज को हमने ग्रेटर ऑटोनॉमी दिया. फिर जो नॉर्थ ईस्ट ट्राइबल ग्रुप्स थे उन्होंने कहा कि हमें ज्यादा ऑटोनॉमी चाहिए कंपेयर टू ऑटोनॉमी और गिविंग टू रेस्ट ऑफ इंडियाज ट्राइबल ग्रुप्स. वी सेड फाइन, रीजनेबल इनफ, यू हैव लिव्ड अंडर ग्रेटर ऑटोनॉमी, विल गिव यू मोर ऑटोनॉमी. सो वी फाइंड दैट सच एक्सपेरिमेंट्स वी हैव डन. तो हम ग्रेटर नागालैंड नहीं होने देंगे, हम सेसेशनिज्म नहीं होने देंगे, बट वी विल एक्सेप्ट डिमांड्स फॉर ग्रेटर ऑटोनॉमी विद इन यूनाइटेड इंडिया under the Indian Constitution. Whatever is feasible, we'll do that. नहीं, हमने किया है काफी नेगोशिएट करके. नागालैंड में काफी, है ना, जो भी उनका NSCN के डिमांड्स थे उसमें भी 2 ग्रुप्स थे इनके, हमने काफी इनके साथ नेगोशिएट करके काफी पीस है. आज के दिन देयर इज दिस डिमांड फॉर ग्रेटर नागालैंड हैज सब्सटैंशियली सबसाइडेड. एक समय था जब ये इंटरनेशनल प्लेटफॉर्म्स तक पहुंच गए थे, वहां पे भी दे यूज्ड टू रेज डिमांड्स फॉर ग्रेटर नागालैंड, ठीक है. तो अब वो चीज नहीं है. Over the years, of course, there has been greater integration. Indian state has actually done a very good job in integrating and creating a sense of belonging, a sense of, you know, oneness amongst all of us. We all feel there is a stake for us in this Indian state. Fine. Single constitution, single citizenship, और बताओ. What else? Yes. If we look at the essential features, yes, coming back to the essential features, can we come out with some points there? Dual polity, fine, we have dual polity. Bicameralism, we have bicameralism, but as far as Rajya Sabha is concerned, we find there is unequal distribution of party, unequal representation of states in Rajya Sabha. कुछ states हैं, UP, which will hold many more seats. Sikkim will hold very few seats. Yes, तो हमारे यहाँ unlike US, वहाँ पे है House of Senate कहते हैं उसको, ठीक है. तो वहाँ पे हर state, the Senate comprises 100 members from each American state. There are 2 representatives sent to the Senate. But in case of India, that is not the case. We do not find equal representation of states, rather unequal representation of the states. Yes, in Rajya Sabha, that is one concern. Then there is this need for rigidity. ये दोनों तो है बिल्कुल. अब rigidity of the constitution is an essential feature, but we also find there is flexibility. To an extent, there is also flexibility in the Indian Constitution. So ये सारे features है ना, cumulatively we say show, highlight the unitary bias या unitary tendency of Indian Federation. अच्छा, one of these days, है ना, there was this a student who came up to me and we were discussing that as far as I've told you this prior to this also, in terms of flexibility भी हमने example दिया था. Flexibility of Indian Constitution, the central government can change the boundaries, can create new states as if it is enacting an ordinary law by simple majority, 50% of those present and voting. Yes, that means as far as India is concerned, we say India is an indestructible indestructible union. Why? Unity and integrity of India is very, very important. We are not ready to compromise with unity of India, integrity of India. So we are an indestructible union with destructible states. Yes. However, in case of US, which was the first federation, which we identify as model federation at times, जब इंडिया को क्वासी फेडरेशन बोला जाता है या क्वासी फेडरल बोला जाता है तो यूएस मॉडल को रिमेंबर किया जाता है. सो इन केस ऑफ यूएस you find it is an indestructible union of indestructible states. वहां पे states का भी territorial integrity is guaranteed. You cannot break away a state. You cannot disintegrate. You cannot change the borders, alter the areas of a state. Yes, but in case of India, that is not the case. In case of India, we are an indestructible union with destructible states. Fine. So that is, these all are examples of. I hope you have understood this. Yes. Therefore, we find that we say that we are a country with unitary bias. Fine. What is the reason why we are an indestructible union with destructible states, or they have indestructible states? Why? Because देखो डाइवर्सिटी तो यूएस में भी है ना. तो यू फाइंड दैट एज फार एज द जेनेसिस इज कंसर्न, हाउ वाज इंडियन फेडरेशन फॉर्म्ड, हाउ वाज यूएस फेडरेशन फॉर्म, है ना. यूएस में क्या था, 13 इंडिपेंडेंट कॉलोनीज केम टुगेदर एंड सेड वी लेट अस फॉर्म यूनाइटेड स्टेट्स ऑफ अमेरिका. यस, बट इन केस ऑफ इंडिया, did the states come together? No. In fact, there was this central country of India, and we said, okay, for recognizing the rights, for recognizing the diversity, let us create states and give them some power. हमारे यहाँ India existed first and then the states were created, and states have been created for administrative convenience, for allowing greater representation rights to the diversity and a greater autonomy to represent the diversity. लेकिन यूएस में क्या हुआ, states came together, states already existed and they came together, 13 colonies who had got independence from British, the 13 American colonies came together and said that let us form the United States of America. तो उन्होंने कहा कि हम अपना थोड़ी ना, वो जब खुद आ रहे हैं वो अपना टेरिटोरियल इंटेग्रिटी थोड़ी ना कॉम्प्रोमाइज करने के लिए रेडी होंगे. यस, दैट इज द रीजन हाउ द इंडियन फेडरेशन वाज क्रिएटेड, हाउ यूएस फेडरेशन वाज क्रिएटेड, टेल्स अस why this difference between the two, why India is an indestructible union with destructible states, and why US is an indestructible union of indestructible states. Fine. Let us write it down now. Yes. क्या नहीं हो सकता है स्टेट अलग, वो फेडरेशन है, फेडरेशन में स्टेट्स कैसे अलग हो सकते हैं, indestructible union है. States do not have the right to secede either in India or in US. एक अलग कंसेप्ट होता है कॉन्फेडरेशन, वहां पे स्टेट्स के पास राइट टू सेसीड होता है. लेकिन आज के समय में देर इज नो कंट्री विच क्वालिफाइज एज एन कॉन्फेडरेशन. फाइन. फेडरेशन में इट इज ऑलवेज एन indestructible union. The union cannot be destroyed. No states have the right to secede. Fine. Mm. 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 वी विल कम टू इट, अभी नहीं जाएंगे. बिकॉज देखो, जो एसेंशियल फीचर है, डिविजन ऑफ पावर है कि नहीं, कॉन्स्टिट्यूशन में डिविजन लिखा हुआ है कि नहीं, यस, इज द कॉन्स्टिट्यूशन सफिशिएंटली रिजिड व्हेन इट कम्स टू डिविजन, ऑल्टरेशन ऑफ एनी डिविजन ऑफ पावर. Yes, do we have an independent judiciary which can act as an independent adjudicator in case of a dispute arising between center and state or state and state? Yes, so all those features are fulfilled. Therefore, we are a federation. Now we have to understand that, देखो, जो अगर हमें फेडरल मॉडल लेना है, यूएस में है, यूएस में क्या है, पावर ज्यादा स्टेट के पास है, थोड़ा कम पावर सेंटर के पास है. ठीक है. जब यूएस शुरू हुआ था, व्हेन यूएस वाज क्रिएटेड, देयर वाज मोर पावर गिवन टू द स्टेट एंड लेस पावर गिवन टू द सेंटर. Yes, why was such a distribution of power acceptable in US? Because the way it was created, it was 13 independent colonies who were coming and saying, let us form a United States of America. But that did not mean they wanted to give away the powers they had. Yes, they wanted to preserve maximum of their powers while also ensuring कि अगर हम एक बड़ी कंट्री फॉर्म कर लेंगे तो ऑफ कोर्स देयर इज इकोनॉमी ऑफ स्केल, है ना, ट्रेड में ज्यादा बेहतरी रहती है, इंटरनेशनल फोरम्स में योर वॉइस कैन बी मोर इजीली हर्ड, है ना. कुछ स्टेट हैं जो एग्रीकल्चर में आगे हैं, कुछ स्टेट है जो इंडस्ट्रियल प्रोडक्शन में आगे हैं. तो एनीवेज इट विल क्रिएट अ मोर, है ना, ज्यादा बेनिफिट होगा उन लोगों को. इसीलिए वो यूएस क्रिएट किया, यूनाइटेड स्टेट्स ऑफ अमेरिका क्रिएट किया. यस, दैट इज द आइडिया. एंड नाउ हाउ इज इंडिया क्रिएटेड, दैट इज डिफरेंट. So we have to understand that federation is a concept. Now these concepts are not applied in vacuum. Yes, can we, since India does not follow the European model of secularism, should we call India a pseudo-secular country? We cannot say so because these are models. Models का कुछ basic essential feature होगा. सेक्युलरिज्म का एसेंशियल फीचर क्या है? सेपरेशन बिटवीन स्टेट एंड रिलीजन. स्टेट शुड नॉट इंटरफेयर इन द मैटर्स ऑफ रिलीजन पर से, है ना. तो वो चीज है. सो यू फाइंड दैट दीज मॉडल्स व्हेन दे आर अप्लाइड, ये सोशल सर्कमस्टांसेस में अप्लाई होते हैं. दे आर नॉट, हम नेचुरल साइंस नहीं पढ़ रहे. नेचुरल साइंस में क्या होता है? एवरीथिंग इज इन अ वैक्यूम. आइडियल सिचुएशन में कैसे एटम बिहेव करेगा, कैसे न्यूट्रॉन बिहेव करेगा, कैसे इलेक्ट्रॉन बिहेव करेगा. लेकिन यहाँ पे human society में those concepts are being applied, and human society we have a way of existence. अब suddenly सबका वैल्यू सिस्टम सेम नहीं हो सकता ना, सभी इंडिविजुअल का एक ही वैल्यू सिस्टम हो, ऐसा तो नहीं हो सकता, है ना. वी सिटिंग इन अ क्लास, वी ऑल्सो हैव डिफरेंट वैल्यू सिस्टम्स डिपेंडिंग ऑन द कम्युनिटी वी आर फ्रॉम, डिपेंडिंग ऑन द रीजन, डिपेंडिंग ऑन द लैंग्वेज, डिपेंडिंग ऑन द ज्योग्राफी, टेरेन, हम किस तरह के टेरेन से आ रहे हैं. कुछ लोग दे आर वेरी फॉन्ड ऑफ फिशेस, others might not have access to fishes, है ना. तो वो चीज है कि यार एवरीथिंग इज, है ना, वी आर सोशल बीइंग्स. बहुत सारे फैक्टर्स है जो इम्पैक्ट करते हैं. तो अगर एसेंशियल फीचर्स मीट हो रहे हैं then that is fine. That is the criteria to call oneself federal state, call oneself a secular country. Yes, fine. Please explain why we are indestructible and how. See, India is an indestructible union. मतलब कोई भी state, कोई भी region does not have right to secede. Secede मतलब go its separate way, come out of the Indian state. जैसे मैंने एग्जाम्पल दिया नागालैंड में, वहां एक मूवमेंट था ग्रेटर नागालैंड। तो अब ग्रेटर नागालैंड दे सेड दे वांट टू क्रिएट एन इंडिपेंडेंट कंट्री ऑफ ग्रेटर नागालैंड, विच इज अनएक्सेप्टेबल टू इंडिया। हम ये नहीं होने देंगे, है ना। जब तक हमारा बस चलेगा, जब तक हम till the time we can exercise power, we will ensure that greater Nagaland is not created, because India is an indestructible union. Today Tamil Nadu cannot say I want to form a independent country, है ना, or any other state cannot say that okay, we are done with India, now we want an independent existence. That is not possible. Our constitution does not allow secession of any state. So we are an indestructible union. Yes, this is what we mean indestructible union. मतलब क्या है, जो इंडियन स्टेट का टेरिटोरियल इंटेग्रिटी है, that is constitutionally guaranteed. Yes, no state has the right to say I want to secede out of India, है ना. तो that is the idea. For example, if I can, है ना, थोड़ा far stretched example, लेकिन EU है, यूरोपियन यूनियन, वहां पे ब्रिटेन एक समय उसका हिस्सा था. Britain was once part of European Union. Later on they decided they do not want to be part of European Union, so they could legally come out of it. There was a legal provision which they utilized to come out of European Union. There is no such legal provision under the Indian Constitution which allows states to come out of the Indian Union. So we become an indestructible union. And we are an indestructible union of destructible states. That means constitutionally there is a provision to alter the boundary, to alter the geographical area of the Indian states. We see the state of UP getting divided to create another state of Uttarakhand, Bihar getting divided to create Jharkhand, Madhya Pradesh getting divided to create Chhattisgarh, Telangana created from Andhra Pradesh. So there is constitutional provision. So we are an indestructible union of destructible states. States can, their territorial integrity can be altered with. Yes, so that is the idea. Their names can be changed, their borders can be changed, their areas can be increased or decreased, whatever it is. Fine, I hope you understand. यस, ये सब हम डिस्कस करेंगे. अभी वही है ना कि यूएस ने पहले ये कंसेप्ट लेकर आया फेडरेशन, तो इसीलिए दुनिया भर में सब क्या कहते हैं कि यूएस मॉडल को फॉलो करो. यस, इट इज इन कंपैरिजन टू यूएस मॉडल वी आर कॉल्ड क्वासी फेडरल, बट देन दैट इज नॉट राइट. वी हैव टू अंडरस्टैंड, एज आई वाज टेलिंग यू, इन सोशल स्ट्रक्चर्स, है ना, इन सोशल सिनेरियो, these concepts when they are adopted, they are not adopted in vacuum. There is a pre-existing way of life, there is a pre-existing value system, how we interact, how we think of ourselves. So when you adopt a concept and bring it within a social setup, there are bound to be certain changes. In fact, we need to appreciate the ingenuity, है ना, the geniusness of our constitutional makers who were able to understand Indian circumstances and made necessary changes into such models. हाँ, अगर हम blindly replicate करेंगे तो हम sustain नहीं कर सकते, है ना. तो ये हमारा ingenuity है, ये हमारा, है ना, this is something which is to be appreciated, which other countries also need to learn from India, that you have to adopt models, but then adopt to your own circumstances. One model fit all will never work. One size fit all will not work. Yes, that is the idea. Fine, fine. Let's write it down. Yes, evidences of. You give this heading: India, a federal form of government with unitary bias. Evidences or examples. Yes, all of you have given this. Write down point number 1. The first point that we'll discuss is division of power. Division of power. Division of power is biased. Division of power, write down, is biased in favor of the center. Is biased in favor of the center. Yes, write down. Under it, write down the schedule 7. The schedule 7 creates three lists. Creates three lists, namely the union list, comma, the state list, and the concurrent list. And the concurrent list. Change the paragraph, same point. There are more subjects included under the union list. There are more subjects included under the union list, as well as more important subjects important subjects compared to the state list. Full stop. Change the paragraph, same point. In case of conflict between the central and the state law, enacted vis-a-vis, with respect to a subject on the concurrent list, comma, the central law will prevail. Next point. Point number 2. Write down residuary power. Yes. Comma, that is power to legislate on subject matters, not mentioned under any of the three lists under schedule 7, comma, in case of India lies with the center. Yes, so the residuary power in case of India lies with the center. Next point. Third point. Territorial integrity of Indian states. Territorial integrity of Indian states is not guaranteed. Write down, India is an indestructible union. India is an indestructible union of destructible states, of destructible states. Yes, put it in single inverted commas, indestructible union of destructible states, while US, comma, the first federal government is an indestructible union, is an indestructible union, indestructible union of destructible states, sorry, of indestructible states, of indestructible states. Yes. Next point. Next point. Single constitution, single constitution. Next point, single citizenship, single citizenship. Yes, I'm not explaining these words, they are self-explanatory. Yes, next point. Emergency provisions, emergency provisions. Emergency provisions under which the federal distribution of power, the federal distribution of power is suspended and India transforms into a unitary government. Unitary government. Next point. Governors, comma, constitutional heads of the states, constitutional heads of the states are appointed by the central government, by the central government. Next point, presence of all India services, presence of all India services, namely IAS, IPS and Indian Forest Service. Write down recruitment, recruitment and appointment is by the central government, while the officers serve a majority of their terms, while the officers serve the majority of their terms, under the state government, Yes. Fine. So these are some of the features as far as which indicate the unitary bias or centralizing tendency of Indian Federation. Fine. Write down Next, give the subhead. Reason why India adopted a federal government with unitary bias. Why did we go for such a model of federation? Yes. What circumstances? Yes, circumstance के context में हम ये बोल सकते हैं there existed, we did not have, है ना, there was the task of integration of the states within India. There existed princely states, more than 500 princely states who had to be brought within the Indian Indian Union. In fact, you find the princely state of Jammu and Kashmir and two other princely states chose not to be part of India. Later on, they were brought. There were also certain territories ruled by other foreign powers other than the Britishers. You had the Dutch ruling Goa, the French presence in certain territories of India such as Puducherry. Yes, so you find that there was this task of national integration at that time, and therefore we chose. We'll say the first reason why we chose such a model of federation is because we wanted to accommodate diversity of India. We wanted to show respect to diversity of India while ensuring unity and integrity of India. So we had twin objective while accommodating and respecting, giving due right of self-representation, yes, self-determination to the diverse population, to accommodate diversity while ensuring unity and territorial integrity of India. Write down first reason. To accommodate India's vast diversity while ensuring unity and territorial integrity of India, while ensuring unity and territorial integrity of India. Yes, fine. So we wanted to accommodate the great diversity, at the same time promote unity and integrity of India. Second, to integrate more than 500 princely states, more than 500 princely states that existed during time of India's independence. Yes. Why did we adopt this idea of single citizenship या single constitution? Single citizenship क्यों adopt किया हमने? We could have gone for the US model of giving dual citizenship. Switzerland में भी है ना dual citizenship है. You find हमने क्यों single citizenship adopt किया? To promote this feeling of oneness, that irrespective of where you belong to, we all have a single common identity, a single highest allegiance to the Indian Constitution. Yes, to create a feeling of nationalism, a feeling of oneness. And despite our diversity, all of us have equal set of rights, equal restrictions on the rights, and equal duties to be performed. There is no difference in the set of rights and duties that we are given under the Indian Constitution. So one might be from Maharashtra, one might be from Gujarat, one might be from Kerala, one might be from J&K. But as such, we all have a single uniform identity, single source of highest allegiance, that is Indian Constitution. All have uniform rights and duties. Fine. तो लिखो ये, to create या to promote a feeling of nationalism, to promote a feeling of nationalism. Yes. And last reason, write down, to ensure efficient planning, to ensure efficient planning for socio-economic development of India. Efficient planning for socio-economic development of India. Yes. What is this point, to ensure efficient planning for socio-economic development of India? डिस्क्रिमिनेशन नहीं, देखो सोशो इकोनॉमिक प्लानिंग के लिए, क्योंकि हम आगे चल के पढ़ेंगे कि जो हमने कहा कि ज्यादा पावर या ज्यादा इंपॉर्टेंट सब्जेक्ट हमने सेंटर को दिया टू लेजिस्लेट. वी विल स्टडी लेटर ऑन, मोर फाइनेंशियल पावर्स वर गिवन टू द सेंटर. ठीक है, तो मोर फाइनेंशियल पावर्स वर गिवन टू द सेंटर एंड लेस फाइनेंशियल पावर्स टू द स्टेट. States in India are in fact dependent on the center as far as their financial needs are concerned. They have been given more function, लेकिन उनको इतने पैसों का right नहीं दिया है ना. They do not have access to much finances. So to perform the functions that have been given to them under the Indian Constitution, they are dependent on the center to provide finances. Why so? Because India at the time of independence was a very poor nation. We had a large population, around 200 million population. Majority of them were extremely poor, living below the poverty line. So the Indian state required to go for centralized planning. If every state would plan on its own, the resources might have got wasted. So we wanted efficient planning. We wanted to promote a centralized planning so as to ensure socio-economic development of India. Therefore, greater powers, the division of power has been tilted in favor of center. Fine. So that is the idea, to ensure socio-economic development and to promote efficient planning. Therefore, this feature of more power. हाँ, सोशियो-इकोनॉमिक डेवलपमेंट का मतलब ही वेलफेयर है. हाँ, सोशियो इकोनॉमिक डेवलपमेंट, वेलफेयर कैसे अचीव करेगा गवर्नमेंट? थ्रू पॉलिसीज एंड स्कीम्स, है ना. वो कहेगा कि पीडीएस लेकर आओ, अंत्योदया फूड स्कीम लाओ, है ना, गरीबों में खाना, है ना, फ्री ऑफ कॉस्ट. यू हैव ऑल्सो, अपार्ट फ्रॉम PDS, we also have an Antodaya food security scheme, है ना, whereby the government gives certain amount of food grains free of cost to people living below the poverty line. Stark poverty में जो है उनको free of cost food grains का भी provision है. Yes, so how all that? Right to work through MG Narega, है ना, through policies and schemes. Welfare is achieved through policies and schemes. Welfare मतलब socio-economic development of the population, है ना, socio-economic development of the poor. Fine. So this is about the federal system with unitary bias, features of Indian Constitution where we find that there is a unitary bias, and the reason why we have adopted such a form of federation. Fine. The next feature of Indian Constitution is we support what is known as an integrated and independent judiciary. Yes, we have an integrated and independent judiciary. Now, what do we mean by integrated judiciary? See, in case of US, there are two systems of court. एक स्टेट लेवल पे कोर्ट सिस्टम है, जो क्योंकि वहां पे डुअल कॉन्स्टिट्यूशन है ना, द स्टेट्स हैव देयर ओन कॉन्स्टिट्यूशन एंड द सेंट्रल गवर्नमेंट हैज देयर ओन कॉन्स्टिट्यूशन. सो यूएस हैज in case of US we have dual system of courts. You have फेडरल कोर्ट्स, फेडरल कोर्ट मतलब जो सेंट्रल लेवल पे है, जो सेंट्रल गवर्नमेंट के लॉज एनफोर्स करेगा, है ना, जो यूएस कॉन्स्टिट्यूशन पे एडजुडिकेट करेगा. यस, एंड देयर इज स्टेट कोर्ट टू एनफोर्स स्टेट लेवल लॉज, स्टेट लेवल कॉन्स्टिट्यूशन एनफोर्स करेगा. Fine. So in US you have dual system of courts, but in case of India we find that there is an integrated judiciary. The judiciary in India is hierarchically organized. In a pyramidal structure we have organized our judiciary. On top is the Supreme Court. Below it is the High Courts, and below High Courts are the subordinate courts. Subordinate court मतलब क्या है? District court and other lower courts जो रहते हैं. Yes, and you find that this is an hierarchical and an integrated judiciary whereby a judgment of Supreme Court will be abided by the high courts as well as the lower courts. So a judgment given by a higher court would be accepted and administered, followed by the lower level of courts. Yes, and a citizen dissatisfied with the judgment at the district court level can go to the high court. Unacceptable judgment not acceptable at the high court level can approach the Supreme Court. Fine. So in case of India, we have an integrated judiciary. That means the Supreme Court stands at the top of the integrated judicial system. Yes, below it is the high courts, and under the high court is a hierarchy of subordinate courts such as the district courts and other lower courts. You have an integrated judicial system. It refers that any decision made by the higher courts have to be followed by the lower courts. And unlike US, where there is a dual system of judiciary, we find that there is an integrated judiciary which is hierarchically organized in case of India. Yes, you have written this heading, integrated and independent judiciary. तो integrated judiciary में लिखो, पहले तो आप ये pyramidal structure draw कर लो. Draw this pyramid. क्या चीज? फेडरल की सेंट्रल लेवल पे है ना. आई वांटेड टू क्लैरिफाई कि फेडरल कोर्ट मतलब जो सेंट्रल लेवल पे कोर्ट है वहां पे उसको फेडरल कोर्ट बुलाया जाता है, एंड इट एनफोर्सेस सेंट्रल गवर्नमेंट लॉज. फर्स्ट यू ड्रॉ फॉर इंटीग्रेटेड जुडिशरी, है ना, दिस pyramidal structure. Yes, so basically the courts are hierarchically arranged. लिखो, hierarchically the courts in India are hierarchically arranged. Yes, hierarchically arranged with Supreme Court at top, comma, below it are high courts, at state level, high courts at state level. and below it are subordinate courts, that is district court, courts, and other lower courts, that is district courts and other lower courts. Yes. नीचे नेक्स्ट पॉइंट लिखो इसी में, इंटीग्रेटेड जुडिशियल सिस्टम. इंटीग्रेटेड जुडिशियल सिस्टम means integrated judicial system means any decision made by the higher courts will be followed by the lower courts. Yes, next point. India has underline a single system of courts. Underline, which enforces both the central and the state laws. Full stop. US on the other hand has a dual system of courts. Dual या double system of courts. Dual या double, anything. Dual system of courts. Put a hyphen in subpoint. Federal court. Which enforces the central laws. And second subpoint, state courts which enforce state laws. Yes, fine. So this is what we mean by an integrated judiciary. In case of India, it is hierarchically organized. It is integrated, that single system of court, and then a decision by a higher court is followed by the lower court. Yes, and single system of court where all the courts, at the state as well as at the federal level, the Supreme Court as well as the High Court is going to enforce both center and the state laws, unlike as is the case in US. Then we also have independent judiciary. Yes, independent judiciary. Yes. Now, how do we ensure independence? Independence of the judiciary is an essential federal feature. Yes. So you need independent judiciary to uphold rule of law, to uphold the constitution. Yes. Now, what are the ways in which we ensure independence of judiciary? Yes. Yes. What are the ways? इंडिपेंडेंस ऑफ जुडिशरी कैसे होगा? सबसे पहले किसी का भी इंडिपेंडेंस होने के लिए अपॉइंटमेंट है ना, शुड बी सच दैट वन इज नॉट ओब्लाइज्ड टू द वन हु इज अपॉइंटिंग देम. यस, गवर्नर की यही दिक्कत है कि ही इज अपॉइंटेड बाय द सेंट्रल गवर्नमेंट. बट इन केस ऑफ जुडिशरी, you find judiciary itself plays the primary role for its appointment, है ना. और उनके यहाँ एक जनरल रूल भी है, जनरली द सीनियर मोस्ट जज will become the chief justice of India, of the Supreme Court, and the Supreme Court, and there is something known as the collegium system. ये सब हम बाद में पढ़ेंगे. collegium system, जिससे जुडिशरी खुद ही है ना, रोल प्ले करती है, खुद ही बताती है एग्जीक्यूटिव को दैट हु शुड बी अपॉइंटेड एज द जज ऑफ द सुप्रीम कोर्ट, हु शुड बी, है ना, अपॉइंटेड एज द चीफ जस्टिस ऑफ द हाई कोर्ट, who should be transferred from one high court to other high court, who should be brought from high court to supreme court. ये सब जुडिशरी ही बताती है एग्जीक्यूटिव को. एग्जीक्यूटिव फॉलोज व्हाट द जुडिशरी सेज. यस, through this means of appointment they are able to ensure their independence. They are not obliged to the executive for their appointment. What else? Freedom from? How is that freedom exercised? How is that freedom available? वही बताना है. Yes, one is security of tenure. हाँ, सिक्योरिटी ऑफ टेन्योर का मतलब ही ये है कि उनका जो रिमूवल है ना, देखो हम इम्पीचमेंट ना प्रेसिडेंट के लिए वो शब्द रिजर्व रखेंगे, जबकि कई बार हम इम्पीचमेंट फॉर सुप्रीम कोर्ट जजेस यूज करते हैं, but it is better if we reserve that word for removal of the president of India. Yes, for other other positions, if somebody has to be removed, we'll simply use the word removal. So the removal of the judges of Supreme Court and High Court is not easy. There is constitution which elaborates the provisions through which these judges can be removed. It is a very strict procedure, strict grounds mentioned. Only when those grounds are fulfilled and only when their parliament votes by a special majority that they can be removed. Yes, so you find that removal is not easy. They have been given security of tenure through it. What else? Allowances and they are also fixed. The salary and the allowances are fixed. They cannot be reduced. They cannot be reduced once the judges are appointed. They can be increased, but they cannot be reduced once the appointment has taken place, once the judges have been appointed. दैट इज एन एक्स्ट्राऑर्डिनरी सर्कमस्टांस. और वो भी फाइनेंशियल इमरजेंसी में इनके कुछ पर्क्स है ना, सैलरीज कम कर सकते हैं, बट दैट इज एन एक्स्ट्राऑर्डिनरी सिचुएशन. ठीक है, नॉर्मल सिचुएशन में इनकी अलाउंसेस एंड सैलरीज आर फिक्स्ड एंड दे कैन नॉट बी रिड्यूस्ड टू their detriment once they have been appointed, after their appointment. Yes, also their salaries tends to be what we say charged on. There are different funds है ना. एक है कंसोलिडेटेड फंड, कंसोलिडेटेड फंड ऑफ इंडिया. कंसोलिडेटेड फंड ऑफ इंडिया क्या है? कंसोलिडेटेड फंड ऑफ इंडिया जो भी टैक्सेस गवर्नमेंट ऑफ इंडिया कलेक्ट करती है, जो भी पेनल्टीज फीस वो हमसे कलेक्ट करती है, जो भी सर्विस चार्जेस वो हमसे कलेक्ट करती है, वो एक फंड में इकट्ठा होता जाता है. There is one fund which has been created in which all that money coming from the people, yes, are put in, and that is consolidated fund of India. So this is the fund through which government is going to meet its expenses. किसी को सैलरी देनी है ना, कहीं रोड बिल्ड करना है, कहीं हाईवे बिल्ड करना है, कहीं पे एयरपोर्ट बिल्ड करना है, जो भी करना है, the money is to come out from the consolidated fund of India. And आपदा के समय, emergency के समय, when there is an emergency, there is something, there are different fund, that is contingency fund. Contingency fund. Yes, we have also something known as contingency fund, है ना. वहां से in case there is a sudden emergency and you want to withdraw fund, withdraw money, then you can access the contingency fund. Now why need for contingency fund? Because if you were to withdraw money from consolidated fund of India, it cannot be withdrawn at the whims and fancies of the executive. You need a parliamentary vote saying that fine, the executive can withdraw this much money. So every year when the budget is passed, it means that the executive will put forward their agenda for the year, that this is the plan First they will say, this was my economic performance in the last year, this is the money I had withdrawn, these are the money that I have spent on these many funds and schemes, on building highways, on building airports, and this is they will present an annual budget statement जो बीते साल का. For the coming year also they will say, these are my proposals, I want to build so much infrastructure, I want to increase the spending on say MG Narega, I want to increase the spending on Atal Pension Yojana, है ना, various schemes and programs, and they will give the proposal to the parliament. Now the parliament will vote on the proposal. Okay, fine, you can spend this much on these schemes, and for it you also need money, so the parliament will also vote that fine, the executive can withdraw this much amount of money over the year from the consolidated fund of India. So suddenly if there is an emergency, the parliament cannot meet and vote and allow for use of the money from consolidated fund. So they have created a contingency fund from where the executive, as per the need, can immediately withdraw and access money. Fine. Now, however, when it comes to salary and allowances of the judges, if these salary and allowances were made votable, if every year the parliament were to vote, this year only this much money will be released for salaries of the judges. Next year maybe 100 crore more. Next year maybe 200 crore less. Then it will create a dependency of the judges on the parliament. So that is what we do not want. We want independence. So the salaries and allowances and pensions are charged. That means they are non-votable. Every year, and depending on the number of judges in the Supreme Court, in the High Court, the pension, the allowances all are calculated, fixed numbers है, ये calculate हो जाता है और ये Parliament को बस बता दिया जाता है, this much amount is going to be spent from the consolidated fund on account of salary, pension and allowances for the judges. The Parliament does not get a right to vote on such expenditure. This ensures independence of further augments the independence of the judiciary. Their salaries are not dependent on the votes by the Indian Parliament. Fine. So that is the idea. जो भी इस तरह के constitutional offices हैं, for example, Election Commission of India, for example, CAG, Comptroller and Auditor General, if you have not heard of these names, you will hear in due course. Newspaper पढ़ोगे रोज तो आएंगे ही ये नाम, है ना? RTI, right to inform, RBI के गवर्नर, है ना? तो you find that जो इस तरह के constitutional posts हैं, उनके लिए उनकी salaries, allowances are charged. They are not votable, so as to ensure their independence. UPSC member, UPSC chairman, है ना? Their salaries would be charged and they are not subject to yearly votes by the parliament because they perform a very important role. They recruit the permanent executive. Yes, without them, and the bureaucrats have been referred to by Sardar Vallabhbhai Patel as the steel frames on which the governance of the country relies. So therefore you find the officers who perform very vital functions, their salaries are not subject to parliamentary vote. Yes, they are simply charged on the consolidated fund of India. Fine. So these are some of the ways in which you find that independence of the judiciary is maintained. Also, one important condition is prohibition on the discussion on the conduct of the judges in the legislature. You cannot discuss how is the judge conducting himself as part of the parliament or the state legislative assemblies. Yes, only if there is a bill, there is a motion which has been put forward for removal of the judge, only then you can discuss how was his conduct. Was it fair? Was it reasonable? Was he biased? Whatever it was, does he show inclination towards corruption? All those things can only be talked about and discussed in the legislature only when a resolution or a motion for the removal is pending before the house. Otherwise you cannot discuss the conduct of the judges. And of course logical hai. Yes, and also the court has power to punish for its own contempt. अगर कोई willfully सुप्रीम कोर्ट का जजमेंट नहीं मानता है, कोई willfully ऐसा काम करता है which interferes with administration of justice by the Supreme Court or the High Court, they have the power to punish for their own contempt. Fine. So these are the ways in which independence of judiciary is ensured. Fine, let's write it down. Independence of judiciary. No, judicial review क्या है? Doctrine of checks and balances. It is a means through which judiciary is exerting check on other branches of the government. It is not a means for its own independence. नहीं वो देखो दैट इज डिफरेंट ना, उसका पर्पस अलग है ना, वो उसका पर्पस है टू प्रिवेंट द एग्जीक्यूटिव और द लेजिस्लेचर फ्रॉम बिकमिंग ऑटोक्रेटिक, है ना, कंसंट्रेशन ऑफ पावर उनमें प्रिवेंट होने के लिए है वो प्रोविजन. दैट प्रोविजन इज नॉट मेंट फॉर इंडिपेंडेंस ऑफ जुडिशरी. इंडिपेंडेंस ऑफ जुडिशरी समझ में आ रहा है? इंडिपेंडेंस ऑफ जुडिशरी अलग है कि उनके काम में कोई इंटरफेरेंस ना हो, कोई तरह का बायस नहीं क्रीप होना चाहिए. देयर शुड नॉट बी एनी बायस in the functioning of the judiciary. Yes, if the appointment was by the central government, the judges might be obliged to those who have appointed them. Yes, they would have to give a judgment in favor of the center in case of a dispute between center and state. So that should not happen. That is the idea. Sorry? Yes. Yes, contingency fund is an emergency fund. वहां से तो हो भी नहीं सकता ना. Regular salaries है, ये तो regular administrative expense है of the government. तो contingency से तो it will not be. This salary has to be drawn from consolidated fund only. But this is the fund which is available. Yes, so to meet the expenses of the government of the day. Fine. They are different, है ना. We have just discussed judicial review. We have not gone into judicial activism. We are not going to discuss it as of now, है ना. Judicial activism हम foundation में पढ़ेंगे, अभी तक judicial review समझ के चलते हैं. ठीक है, judicial review becomes the means for judicial activism. लेकिन अभी हम judicial activism नहीं discuss करेंगे. ठीक है, let us restrict ourselves, क्योंकि फिर foundation में क्या पढ़ेंगे, अभी सब पढ़ेंगे तो. Yes. And we'll get confused. That is not the mandate. अगर हम ज़्यादा higher level में जाएंगे तो confusion होगा. Independent judiciary आपने लिखा है ना. It is ensured through. It is ensured through. It is ensured through. In points, write down appointment of the judges. Appointment of the judges. Yes. Put a hyphen. Through the collegium system. Through the collegium system. Yes. See, this collegium system is not perfect. No system is perfect. Everybody will have fault. So I'm not claiming it to be perfect. I'm just saying that judicial appointment takes place through the collegium system, which results in independence of judiciary. Fine. Collegium system में judiciary खुद ही role play करता है in terms of the appointment. तो है ना, एक group of judges बैठते हैं, CGI होते हैं, और 2-3 और judges मिलके they decide who should be appointed as the judge of the Supreme Court, who should be appointed as Chief Justice of the High Court, है ना. वो सब खुद ही वो डिसाइड करते हैं. Yes. Okay. Collegium system. है ना? There is constitutional requirement also. The constitution says that to become a judge of the Supreme Court, you have to be a prominent jurist, or else you should have been a lawyer for 10 years. And to become a judge of the High Court, you should have been a lawyer for at least 5 years. ऐसे करके कुछ preconditions mentioned है, कुछ requirements, some qualification is mentioned. Not anybody of us can become the judge. So a lawyer can become a judge. Yes, and there is a hierarchy. You have to go through that hierarchy and then you can become. It is not always essential also that you have to be a senior advocate also. है ना? वी आर नॉट गेट, अब उसके प्रोसीजरल एस्पेक्ट में नहीं जाते, बट देर इज कॉन्स्टिट्यूशनल प्रोविजन कि आपको इतने साल एज अ लॉयर यू हैव टू सर्व बिफोर यू गेट अ चांस टू बिकम द जज. बट देर आर मेनी. हाँ, यस यस, ये तो आप प्री कंडीशन है, ये तो आप खुद फुलफिल कर दोगे. बाद में द कोलिजियम विल डिसाइड, ओके दिस पर्सन इज सूटेबल, ही कैन बिकम द जज. बट लॉयर्स, सी एज इंडिविजुअल्स आई हैव अ चॉइस. Do I want to continue my pursuit of being a lawyer, or do I want to become a judge? So these individuals like Ram Jethmalani, they have refused to becoming a judges. They have found this profession to be more fulfilling for them. Yes, they have refused to become judges. So as individuals we have a choice, but once the collegium decides, those who have already become judge, हाई कोर्ट सुप्रीम कोर्ट के जो जज ऑलरेडी बन चुके हैं, अगर उनका ट्रांसफर हो रहा है इधर से उधर, है ना, somebody is being appointed as the chief justice, they generally tend to accept what the collegium has to say. Yes, so that is the idea. The collegium itself comes out, ये बहुत लैक ऑफ ट्रांसपेरेंट प्रोसेस है, बहुत है ना, इनट्रांसपेरेंट है. वो खुद ही एक लिस्ट बनाते हैं, वो खुद ही फिर बताते हैं कि ये तो एप्लीकेबल है, ये नहीं एप्लीकेबल है. दैट इज हाउ इट ऑपरेट्स. फाइन. कि किसको कंसिडर करेंगे? देर आर सो मेनी जजेस, नॉट एवरी जज इज कंसिडर्ड एवरी ईयर कि हाँ इसको बना दे क्या, इसको बना दे क्या, है ना. सो हु मेक्स दैट लिस्ट of judges who will be considered for posts? But the executive also can suggest few names there, but ultimate decision is by the collegium. Fine. So appointment is by the collegium system. Next point is security of tenure. Security of tenure. Put a hyphen. Removal of the Supreme Court or High Court judges. Removal of the Supreme Court or High Court judges is based on constitutional provisions. Constitutional provisions. Third, salaries, pensions, allowances, commas, their service conditions are fixed and cannot be changed to their detriment. Cannot be changed to their detriment. DETERIMENT. To their detriment once the judges have been appointed. To their detriment once the judges have been appointed. Next point, salaries, pensions and allowances. नेक्स्ट पॉइंट लिखो, सैलरीज, पेंशन्स एंड अलाउंसेस. सैलरीज, पेंशन्स एंड अलाउंसेस. वापस से लिखना है, सैलरी, पेंशन्स एंड अलाउंसेस are charged on Consolidated Fund of India. Consolidated Fund of India. Fund of India. Yes, next point. Conduct of judges. Conduct of judges. Conduct of judges cannot be discussed. Cannot be discussed. In the parliament. In the parliament. In the parliament. Conduct of judges cannot be discussed in the parliament or the state legislature. Or the state legislature. Except when a motion for their removal is under consideration. Is under consideration. Is under consideration. Full stop. Fine. So these are some of the points through which independence of judiciary is ensured. Fine. Let me get to the few questions that I see here. Ayush says, what do you mean by single system of courts? What do we mean by single system of court? There is one system of court which is hierarchically organized. है ना? तो you have subordinate courts for district courts. Then you have High Court and the Supreme Court. You have an hierarchically organized system of court, and this hierarchically organized system of court would enforce both central and state laws. Unlike US, जहाँ पे दो system of court है, there are two systems of court, dual system या double system of court. There is a federal court to enforce federal laws. There is a state level court to enforce state level laws. That is not the case in India. The Supreme Court and High Court both will enforce both center and the state laws. Fine. So this is what we mean by a single system of court. And the single system of court का मतलब ये तो नहीं हो सकता कि एक ही court है ना? तो there has to be, the courts have to be hierarchically organized ताकि आप appeal कर सको, है ना, with respect to the judgments. So that is the idea. I hope, Ayush, it is clear. Fine. Yes, there are a few students who have a doubt with respect to the collegium system. See, collegium system as such I have not explained. Now let me, if or so many of you are asking, let me tell you about the collegium system in brief. Now what is this collegium system? Collegium system क्या है? The Supreme Court through its judgments, constitution में, there is, in the constitution, there is no provision with respect to the collegium system. The constitution keeps mum, does not talk about collegium system. It is an innovation of Indian judiciary itself. ठीक है, Indian judiciary through its various judgments has come out with what is known as the collegium system. Collegium system in case of appointment to the Supreme Court. If a person has to be appointed as a Supreme Court judge, in that case the collegium will comprise of the CGI. है ना? The collegium will comprise of the CGI, Chief Justice of India, plus 2 Supreme Court judges, 2 senior Supreme Court judges. ठीक है, तो this is the collegium. Collegium मतलब collection. So these 3 individuals, they will discuss, debate, deliberate amongst themselves whether this one person is right enough to be appointed as the Supreme Court judge or not. है ना? तो a person who has been serving as a High Court judge, if he has to be brought to the Supreme Court, उसको अपग्रेड करना है ना, उसके लिए दिस इज एन क्या कहते हैं, सीनियर पोस्ट है ना. सुप्रीम कोर्ट जज इज अ रिलेटिवली सीनियर पोस्ट. इफ somebody has to be made from a high court, has to be brought into the Supreme Court, the collegium will comprise of CGI plus the two senior most judges of the Supreme Court. They will discuss and deliberate if this person is right enough to be made a Supreme Court judge or not. Yes, and if they feel this person is right, they will tell, है ना, they will tell the central government, है ना, that yes, this person should be appointed. So the collegium system, yeah, the collegium will tell the central government, yes, this person should be appointed as a Supreme Court judge. In case supposedly a person has to be appointed as a High Court judge, as a High Court judge, ठीक है, or is to be transferred from one high court to another. Yes, in that case, है ना, let us just keep it simple, एक हाई कोर्ट का जज बनाना है किसी को. In that case, the collegium will comprise of the CGI, Chief Justice of India, the Chief Justice of the High Court in which he is to be appointed, plus once again 2 to 4 senior most judges of Supreme Court. They will discuss and deliberate whether this person should be appointed as judge of High Court or not. Basically collegium system, अगर हम इस डिटेल में ना भी जाएं, it is a collection of judges who will discuss and deliberate and suggest to the central government whether a person is eligible, whether a person is a rightful candidate to be appointed to Supreme Court or High Court. ठीक है, तो यही है कोलिजियम सिस्टम. लेकिन कोलिजियम सिस्टम की दिक्कत, एक मैंने वर्ड किया था, लैक ऑफ ट्रांसपेरेंसी. अब इनका क्या दिक्कत है कि ये इनका क्या प्रोसेस है, what is the principles, what are the criteria they consider, they have not told. What is the process of deliberation, what was the deliberation which took place, ये कुछ भी पब्लिक को रिलीज नहीं करते. इट इज अ वेरी इनट्रांसपेरेंट प्रोसेस. वो अपने आप में डेलिब्रेट करते हैं और बस वो अपना फाइनल वर्डिक्ट सुना देते हैं. Yes, so that is a problem that we have. We want greater transparency. We want to know what is the criteria that you followed to select this individual and reject that individual. ये कॉन्स्टिट्यूशन में तो लिखा नहीं है, ये सुप्रीम कोर्ट ने अपने जजमेंट के थ्रू क्रिएट कर लिया. अब सेंट्रल गवर्नमेंट कोशिश कर रही है, क्योंकि कोलिजियम हर सिस्टम में दिक्कत होती है, तो सेंट्रल गवर्नमेंट भी चाहती है कि कोलिजियम सिस्टम को हटा दिया जाए, वो खुद कुछ रोल प्ले करे, है ना, इन दी अपॉइंटमेंट. बट उन्होंने इसके लिए क्रिएट करने का कोशिश किया एनजैक, नेशनल जुडिशियल अपॉइंटमेंट काउंसिल. ठीक है, उन्होंने कोशिश किया एक नया काउंसिल क्रिएट करे जो कोलिजियम को रिप्लेस कर देगा. लेकिन सुप्रीम कोर्ट का जजमेंट आया कि ये अगेंस्ट द कॉन्स्टिट्यूशन है, दिस वायलेट्स इंडिपेंडेंस ऑफ जुडिशरी. तो आज के दिन भी हमारे यहाँ कोलिजियम सिस्टम ही कंटिन्यू कर रहा है. फाइन, सो दैट इज, दिस इज कोलिजियम. कोलिजियम इज कलेक्शन ऑफ जजेस coming together deliberating whether a person should be made a Supreme Court or a High Court judge. Yes, with respect to CGI you said, तो CGI का क्या है, अगर CGI का अपॉइंटमेंट है उसमें कोलिजियम का ज्यादा रोल नहीं रहता. CGI is appointed based on seniority, है ना. तो जो आउटगोइंग CGI होता है वो बोल के जाता है कि दिस पर्सन विल बिकम द नेक्स्ट CGI, और उसका कोई खुद का चॉइस नहीं है, इट इज बेस्ड ऑन सीनियरिटी. So at times there have been incidences कि कोई CGI have been served as Chief Justice of India for only few days because उसके बाद वो रिटायर हो रहे थे. तो है ना, इस वजह से बहुत कम दिनों के लिए भी कई बार CGIs have 63 या 65 है ना, for as far as Supreme Court. लेकिन नहीं, तो बेसिकली अब वो होगा ना कि वो बस 6 महीने में 65 टर्न हो रहे हैं. तो he served only for 6 months as CGI. Age. एज एक्सपीरियंस भी है लेकिन ज्यादा एज है, और एक्सपीरियंस भी है, वही है, क्यूमुलेटिव है ना, दे हैव देयर ओन कंसिडरेशन. फाइन. Fine. Now there is also another question. Fine. Fine. I'll repeat the questions. And they have some confusion with respect to the questions that you are asking. They do not understand. What is the Consolidated Fund of India? Consolidated Fund of India, as I told you, and there are different funds. And there are actually three types of funds created under Indian Constitution. And the most important fund that we should know about is Consolidated Fund. ये तीन फंड है जिसका डिटेल आप फाउंडेशन कोर्स में पढ़ोगे. We today got to know about two funds, Consolidated Fund and Contingency Fund. Consolidated Fund क्या है? गवर्नमेंट के पास पैसे कोई होना चाहिए ना, कोई एक अकाउंट जिसमें सारे पैसे आ रहे हैं, है ना. इफ सम ऑफ यू माइट, इफ यू हैड वर्कड और वंस यू स्टार्ट वर्किंग यू विल हैव एन अकाउंट वेयर योर सैलरी गेट्स क्रेडिटेड. अगर आप कोई एंटरप्रेन्योर भी हो तो भी आप एक अकाउंट बनाओगे जहां पे आपके सारे पैसे आएंगे. तो वैसे गवर्नमेंट ने भी एक फंड बनाया है जहां पे उसके सारे पैसे आते हैं, उसको कहा जाता है कंसोलिडेटेड फंड ऑफ इंडिया. और गवर्नमेंट का सोर्स ऑफ अर्निंग क्या है? टैक्स है, रेवेन्यू इन टर्म्स ऑफ, देखो अगर वो कुछ प्रोडक्शन इंडस्ट्रियल कुछ एक्टिविटी में इन्वॉल्व है तो वहां से कुछ पैसे आ सकते हैं, कुछ प्रॉफिट हो सकता है उनको. दे टैक्स है ना, कुछ रेवेन्यू आ सकता है, अदरवाइज दे माइट हैव सम सर्विस चार्ज दैट दे इम्पोज, है ना, सर्टन सेसेस, है ना, एडिशनल टैक्स जो इम्पोज करते हैं, कुछ फीस लगा सकते हैं वो आप पे, है ना. तो ये सारा है सोर्स ऑफ अर्निंग, सोर्स ऑफ रेवेन्यू फॉर द गवर्नमेंट. सो जो गवर्नमेंट का सारा रेवेन्यू है वो एक फंड में इकट्ठा होता है. यस, इट एक्यूमुलेट्स इन वन फंड एंड दैट फंड is referred to as Consolidated Fund of India. All the revenue that the central government gets is put in this Consolidated Fund of India. Fine. So this, and from the revenue only I can spend. So the government spends, generally speaking, from Consolidated Fund of India. And the government, the executive cannot be given a free hand to spend. The executive might end up spending on itself, है ना, खुद ही के लिए स्पेंड कर लेंगे, है ना, खुद ही की पॉलिटिकल पार्टी को वोट मांगने के लिए स्पेंड कर लेंगे पैसे. यस, सो टू एक्सरसाइज चेक ऑन द पावर ऑफ द एग्जीक्यूटिव टू स्पेंड मनी दैट द गवर्नमेंट हैज अर्नड, दे रिक्वायर वोट ऑफ द पार्लियामेंट. ओनली व्हेन they can spend money from the consolidated fund, only after approval by the Indian Parliament. Now Indian Parliament के पास एक ही, गवर्नमेंट तो हर रोज स्पेंड करती है. अब हर रोज तो वो पार्लियामेंट, है ना, इज नॉट मीटिंग every day. The parliament is not in session and the parliament has more important jobs than to just give consent for okay you spend this, okay you spend this. So you find in annual budget for a year the Indian Parliament will give consent for the expenditure, and after the year they will take a stock. Okay, this was the allotted fund, how much did you spend? Did you spend more? Did you spend less? What about the money, remaining money, where is it? Yes, all that stock taking will take place after a year. Fine. So consolidated fund is the fund of revenue that the government has generated, and through this fund the government will spend for developmental purpose, for administrative purpose. Yes, from the Consolidated Fund of India. Fine. I hope it is clear now. Fine. With this we actually conclude the various provisions, salient features of Indian Constitution. Basically we wanted to discuss some few features, and this is not an exhaustive discussion, but an indicative discussion on some important features of the Indian Constitution. I hope it is clear. Yes, we'll just conclude. Yes. Sorry? Government of India cannot enter the list of their names. See, Government of India can ask the collegium that this is my list, will you please consider these 2-3 judges for promotion or for transfer. Ultimate decision, the collegium will consider those names and it will recommend yes or no, whatever it is. And once the collegium has finalized the list, they send it to the government of India. The government of India cannot per se reject the names given by the collegium system. So what do? They sit on it. If they are unhappy with the recommendation, they will not act on it. They will keep the recommendation pending. Yes, so that is what they can do. हाँ, वो क्यों सबॉर्डिनेट कोर्ट के लिए एक तो एग्जाम ही क्यों देगा, है ना? अगर वो चाहेगा तो या तो सीनियर लेवल पे ही वो एवरीबडी गिव्स एग्जाम फॉर सीनियोरिटी. तो अगर लोअर लेवल पे कुछ लोअर लेवल का जज वो लॉयर है, इफ ही गिव्स एग्जाम मे बी एट द सेम लेवल ही कैन बिकम अ सीनियर एडवोकेट और समथिंग ऑफ दैट सॉर्ट, है ना? एक सीनियर लेवल पे चला जाएगा, या फिर ही विल बी अपग्रेडेड टू अ these are procedural questions. अभी इसमें तो नहीं जाएंगे. And see, I am also not very well versed. ये तो पॉलिटी में भी आंसर नहीं होगा, ये कोई जुडिशियल सर्विस में ही जाके आंसर होगा. यू विल हैव टू गो नेट पे सर्च कर लो एक बारी, है ना? दिस इज नॉट विद इन आवर डोमेन पर से कि कौन सा एग्जाम दे रहा है ना. ये तो डिटेल इंट्रिकसीज है उन्हीं के सिस्टम की, तो हम इतना नहीं पता है. फाइन. फाइन. Yes, what are the criticisms of Indian Constitution? We'll just conclude with it. What are some common criticisms that that is, you know, that we make, or that is against Indian Constitution? We call it borrowed Constitution. है ना? कि it is a bag of borrowings. There is nothing unique about it. We have simply borrowed various features from various constitution of the world. Then elephantine size, yeah, very lengthy nature. Indian constitution is the longest written constitution, lengthiest written constitution. So complexity of its language, why such a lengthy constitution is required when the constitution is expected to be a basic framework of governance. How come the Constitution of India has become such a lengthy document comprising 448 articles, 25 parts, 12 schedules? It has become a very, very big document, and it should have been more crisp. Then also this fact that there was the dominance of lawyers. The Constituent Assembly might have been representative of the various sections of the society in terms of community, in terms of gender, but when it comes to profession, it was dominated by the lawyers. Yes, so these are some popular common criticisms against the Indian Constitution. Yes, it is true that we have borrowed, but then we have adapted it to our needs. So we reject this criticism. Elephant in size, yes, it is a very large document, bulky document, that is true. But ये procedural aspect है. Substantively, the Constitution is a very good document, forward-looking document, and it reflects the national consensus in India. Yes, today when the society at times gets very polarized, even then we have consensus over Indian Constitution. So it reflects a national consensus. And dominance of lawyers. Yes, there was a dominance of lawyers. In fact, that is one of the reasons for the lengthy size or the complex language of Indian Constitution, the administrative details which have been entered into the Indian Constitution. But fine, this is true. But it is how it is. But at least they were not individuals who were arguing in self-interest or for self-aggrandizement. They participated in public reason. Yes, they gave reasoned argument and they argued for national interest. So yes, there was dominance of lawyers, but that is how the society was at that point of time. Majority of those who were educated chose the profession of being lawyers. Fine, they were educated in law more often than not. Fine, so that is the reason. Fine, so this is with respect to some general criticism of the Indian Constitution or nature of Indian Constitution. With it, we complete our discussion on the salient features of Indian Constitution. Fine. The next topic that we will be starting with is the rights under Indian Constitution. We are starting with the next topic, that is पढ़ेंगे, अभी वहां पहुंचे नहीं है, फेडरलिज्म का जब टॉपिक में आएंगे तब पढ़ेंगे वो. Rights in break you want. It's it's already 11:20. Do you all want a break? Fine, let's take a 5 minutes break and then we can continue. Chalo, let's take a 5 minutes break and we'll continue. In 5 minutes means 5 minutes, okay? We'll start the class at in 5 minutes. Fine, starting with the class once again. Yes, so we are starting with rights in the Indian Constitution. Now first we need to understand, what do you mean by rights? What do you mean by rights? Fine, essential features of the Indian Constitution or other constitution also talks about right, but not in terms of constitution. What is rights? How do you define rights? हक तो ठीक उसको हिंदी में नहीं बोलना, अलग अलग भाषा में नहीं, इंग्लिश में ही उसको सरल भाषा में बताओ, है ना. इजी लैंग्वेज यू डिफाइन, you explain what do you mean by, what do you understand by rights. Liberty is not a right, है ना. Liberty is freedom. Now freedom can be given as right or not given as right, है ना, in itself. ठीक है, things one can do without any restriction. Any restriction मतलब that becomes an absolute right, है ना. ये absolute, anything absolute is not valid. With reasonable restrictions, freedom to pursue what you want to do, है ना, with reasonable restrictions. What rise does नहीं, what is right पहले बताओ. ठीक है, right, he has said rights are guarantees provided by the state, है ना, through the constitution also. Without the constitution also can we have rights? Yes, certain rights which have been guaranteed to us, not necessarily by the constitution. So fine, I'll accept rights are guarantees provided by the state. Same platform, yes, same level playing field. No, that is not necessarily, है ना. That is the purpose of right, है ना. Purpose of right is to protect citizens from the tyranny of the state, tyranny of the government. That is correct. But what is right? तो वही तो, हिंदी में हक अधिकार नहीं, अभी इंग्लिश में बताओ. See, अच्छा, let me tell you. If we were discussing, chalo, we'll discuss it that way only. If you are the only child of your parents, and once again they have brought cake home and the cake is to be eaten by a child, so is there any question of right? No. Yes, you can eat as much as you want. The cake is for you. You eat as much. You don't want to eat, you dispose it, you give it away to someone, whatever you want to do. The question of right arises when you have a sibling. Yes, when there is somebody else who's contesting for the same thing, then you say, this is my right, this is your right, this is not your right. What you're doing is against your right. You are usurping, you are taking away my right. Yes, so it does not, first and foremost, rights do not arise in vacuum. Rights are claims that an individual makes when there is a group of individual. ग्रुप ऑफ इंडिविजुअल स्टेट लेवल पे हो सकता है, ग्रुप ऑफ इंडिविजुअल सोसाइटी लेवल पे हो सकता है. तो सोसाइटी में ये जब इंडिविजुअल्स एग्जिस्ट एज अ ग्रुप, देन कम्स द आइडिया ऑफ राइट्स एंड ड्यूटीज. इफ आई वर टू एग्जिस्ट ऑल अलोन इन दिस, आई वर टू सिट ऑल अलोन इन द क्लास, there is no question of rights or wrongs. and if there was only one student in the class, that student can ask question whenever he or she wants. There is no question about this. Raise your hand. Now this person will say, he said first, she said first, whatever it is. So rights, the concept of right emerges as far as there is a group of individual which exists. So we say rights are claims made by individuals which are recognized by the society, which are recognized by the state. We can say rights are entitlements given to an individual by the society, by the state. Fine. So this is how we define rights. So basically, rights are claims made by a person over other fellow beings, over the society, over the government or the state. Fine. And for any claim to transform into right, right क्या है? जो legally recognized है ना? उस पे consensus है कि हाँ ये तो इसका right है. So for it to transform into right should have three qualities. It should be reasonable. I cannot claim absolute rights. I cannot say I'll do whatever I want. I will drive. I have bought this car, so I'll drive it as I wish on the street at whatever speed I want, and I'll stop whenever I want. That is not reasonable. I have to, it is my car. I will drive it at a reasonable speed. I will follow the traffic signals so that all of us can drive. Yes. So reasonableness का मतलब क्या है? If similar claim is made by the other person, that should also be acceptable. Yes. So the rights have to be reasonable. For claims to become into right, they have to be reasonable. They have to be recognized by the society. The society should agree. There are certain rights which are agreed by the Indian society, which US society might not agree. Or certain rights which are agreed by the US society, which Indian society will not agree. Chinese state might not agree to certain rights. Indian state might agree to certain rights. Yes. So that is है ना. तो ये societally भी acceptable होना चाहिए. For example, in case of the West, especially US, what we are familiar with. Yes, once the child attains 15, 16, 14, 15, 16, 17 years of age, they are expected to start earning. By 18, you are expected to move out of the house and self-sustain yourself. Yes, while studying. This parents might sponsor your education, but while studying, you should be in a position where you are able to sustain yourself. But that is not acceptable in case of India. If you do that, your parents will not like you. Yes, they want to be present in your life very much till the time you're married and after that. Yes. So that is the nature of Indian society. So if I claim a right, no, I want to move out of my house and self-sustain myself as I want to buy a car of my own money. My parents might not accept. Yes, because that is not acceptable in Indian society, but US society, it will be very much appreciated. So it should be recognized by the society and it should be sanctioned by law. It should be enforceable. Only then right gets utmost value. So once it is sanctioned by law, somebody else does not allow me to exercise my right, I can approach the Supreme Court, High Court, the judiciary. Yes, the district court, whatever it is. Fine. So this is how we define rights. Write it down. Rights are claims. Rights are claims of a person. Rights are claims of a person over other fellow beings, comma, over the society, and over the government. Next point, for claims to become rights, they should satisfy, they should satisfy three conditions. Three conditions. First condition is reasonability. 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 Put a hyphen. Yes. If similar claims are made by others, comma, it should be possible to make them available to others in equal measures. Yes. Second condition, recognized by the society. Recognized by the society. Put a hyphen, write down the notion of right. The notion of right. Yeah, the concept of right changes from time to time. Changes from time to time and from society to society. From society to society. Yes, for example, and we can give the example of voting rights to women. So if 200 years back somebody talked about universal adult franchise and voting rights being extended to women, nobody would accept it because women were not looked at as equal to men, है ना? They were looked at subjects, ना? Subordinate position था उनका. Similarly, Saudi Arabia as a nation has given women a right to vote as late as 2015. So that also itself is quite absurd. Yes, for the world, the kind of world where we are living in, where we talk so much about democracy and individual rights, women not being given a right to vote, half of the citizenship of your country, है ना? Gender based इतना severe discrimination where women are not thought to be capable to choose who should govern them, है ना? Is a gross denial of human rights. अभी तो ऐसा लगता है. Yes. So you find that this idea of right changes from time to time and societies to society. Once child marriage was thought to be right, once sati practice was thought to be the right practice, but today they are considered a gross human rights violation of individuals. Yes, so that is what it changes from time to time and from society to society. So Taliban does not allow women to go out in public without being escorted by men. But in case of India, there is no such prohibition. We have equal right to access public spaces. Yes, we have choice what to wear. Taliban tells men that you have to wear these clothes, women you have to wear these clothes. Women have been denied right to secondary education. But in India, we can study as much as we want. In most liberal democracies, citizens have the right to study as much as they want. Fine. Write down. इसमें for example, 200 years ago, right to vote to women would have sounded strange. And presently, that Saudi Arabia that Saudi Arabia gave their women right to vote right to vote as late as 2015. Sounds strange. As late as 2015 sounds strange for liberal democracies. Yes, full stop. So it varies, this concept of right varies from time to time and from society to society. Yes. Next reason is, next condition is sanctioned by law. Write down, put a hyphen, write down, when the rights, when the claims recognized by the society comma are written into law comma they acquire real force. Full stop. They become enforceable. Underline it. What does this mean? Write down, in case when fellow citizens or the government do not respect one's rights, comma, one can approach the court. Fine. So this is how we describe, right? These are claims made by individuals against other fellow individuals, against society, or against the state. And 3 essential conditions to be fulfilled for a claim to be recognized as a right: that they should be reasonable, they should be acceptable to the society, and enforceable by law, recognized by law. Fine. Yes, some online students have also given good definition. For example, there's a good definition given by Kavya. Kavya says rights are nothing but claims mentioned in the constitution and acceptable by society. And so somewhere she touched upon 2 preconditions for claims to be recognized, into claims be recognized as rights. Fine. Achha, next is this idea of evolution of rights. And I have mentioned everything that is to be mentioned as part of PPT. I'm not going to make you write. It is very historical. तो हम इसको लिखना नहीं चाहेंगे, ठीक है? तो अभी क्या है? Evolution of rights. So you find that this concept of rights have evolved, over several hundred years. The first time the concept of human rights was recognized was way back, is traced to 539 BC. Yes, before Christ. You trace the concept of human rights. Now first, what do you mean by human rights? How do you define human rights? Fine. Food, shelter and cloth. What else? How do you define human rights are certain rights which are given to all human beings. And all human beings by the virtue of being humans. These are certain rights. इसको किसने दिया है? इसको स्टेट ने नहीं दिया है, इसको नेचर ने दिया है. Just because we all are human beings. So irrespective of our color, irrespective of caste, race, religion, yes, the language we speak, and irrespective of all differences, certain common set of rights that we all should enjoy just because we are human beings. The condition for enjoying these rights are that we are human beings. Yes, and these rights have been given to us by nature. And the role of the state is to protect and enforce these rights. Yes, the state does not give us human rights. The role of state is to protect human rights. Yes, and human rights are those rights which are essential to express individual personality. You cannot not have right to speech, freedom of speech and expression. It is a very essential human right. This right has been given to us by nature. And how do you justify having the right to freedom of speech and expression? We are the only animal species on the planet of the earth who has such a sophisticated language, who can communicate in this manner. Yes, our brains are developed in such a manner that we have created languages for communication. Now, since we are the only species on the planet of the earth who has the ability to communicate through distinct languages, that means nature wanted us to communicate. Nature gave us this right to freedom of speech and expression. Only through freedom of speech and expression can we express our individual personality, our individual choices. Yes, we can communicate. Our ability to exist. Why has human beings persisted on the face of the earth? है ना, यहाँ पे भी there is this discussion कि in fact हम हैं Homo sapiens sapiens, है ना. There were other species of this genus Homo sapien और उसमें हम कौन से variety है? Homo sapien sapiens है. एक था होमो इरेक्टस, निएंडरथल्स, ऐसे करके है ना. और भी थे ह्यूमन बींग्स जैसे हमारे जैसे दिखने वाले लोग, और भी थे, लेकिन सिर्फ हम ही सरवाइव कर पाए. उसका रीजन पता है क्या है? वन स्कूल ऑफ थॉट सेज दैट द रीजन व्हाई ओनली वी हैव सर्वाइव्ड एंड नॉट अदर होमो सेपियंस, है ना. दुनिया में जब ह्यूमन बीइंग शुरू हुए तो देयर वर अदर होमो सेपियंस आल्सो, जिनकी शायद नाक थोड़ी बड़ी थी, जिनके कान थोड़े अलग थे, जिनका ब्रेन हमसे बड़ा था, हमसे छोटा था, है ना. बट ओनली वी होमो सेपियंस हैव सर्वाइव्ड. व्हाई? बिकॉज वी कैन टॉक एंड वी गॉसिप. यस, दिस इज एन एसेंशियल कैरेक्टरिस्टिक फॉर आवर सर्वाइवल ऑन द फेस ऑफ द प्लैनेट. वो भी इवॉल्व होते टाइम के साथ, है ना. उन लोग भी, देयर हैव बीन होमो, आई थिंक सो इट वाज होमो इरेक्टस, जो हमसे ज्यादा समय इस धरती पे रहा है. हम रिलेटिवली, हम अभी उतना समय हमने रहा नहीं है. हम वी हैव नॉट लिव्ड ऑन द planet for as many years as Homo erectus lived. And there have been species who had bigger brain capacity and who were intellectually far more greater than us, but they could not survive because they did not tend to gossip. Gossip is identified as a very, very essential feature why Homo sapiens sapiens survived. So how can you take away the freedom of speech and expression from us? Yes, so that is the idea. So these are certain rights given to us by nature. Fine. So the right to form association. Human beings, we are social animals. We cannot exist in solidarity. And solidarity unitary solidarity confinement is the worst form of punishment you can give to a person, because we are social beings. We want to interact, we want to talk, we want to coexist as a part of a society. Yes, so that is the idea. Fine. So these are human rights. अच्छा लिख लो एक बार, human rights लिखो. Evolution of rights, give the heading, and under it we'll just define human rights. human rights are a set of rights, given to human beings, irrespective, yeah, irrespective of race, color, creed, religion, gender, etc. just by the virtue of being human beings, यही condition है to get human rights, full stop. These rights have been given by nature, तो इसको इस ब्रैकेट में लिख लो, नेचुरल राइट्स. नेचर ने जो राइट दिया है उसको बोलते हैं नेचुरल राइट्स. and state is to protect these rights. इसी में लिखो नेक्स्ट पॉइंट, these rights are essential for expression of our individual personality, Yes, so you find that this is how we define human rights, which were first recognized. Its origin is first traced. Yes, recognition of this right is first traced to 539 BC. And in fact, we can understand this evolution of human rights if we look at evolution of the understanding of we can understand rights, evolution of rights, by understanding the evolution of human rights. So we find that human rights have evolved through various generations. Yes, evolution of human rights bolo ya rights, they have evolved through several generations. First generation is recognition of civil and political rights. So right to peaceful assembly, right to freedom of speech and expression, right to vote, and all these क्या है examples? Right to freedom of speech and expression, right to assembly, है ना, right to form associations या political parties. Yes, right to vote. All these are essential civil political rights. Right against arbitrary arrest, right against arbitrary taxation. Government cannot arbitrarily start taxing us. We've earned the money with a lot of hard work. And there has to be some rationale behind taxation. Without our consent, they cannot impose taxation on us. Yes, so only a representative government can impose taxation as such. Yes, so against arbitrary taxation and all such things are certain examples of civil and political rights. These are first generation rights. Then people realized, initially people were demanding only civil and political rights. People thought that once they get these rights, their life will be good. They will be able to live life to their fullest potential. Yes, but once these rights were given, we realized we need some more rights. ये तो ठीक है, लेकिन इसके अलावा भी राइट्स चाहिए टू इनफैक्ट live a better quality of life. So we started demanding for the second generation of rights. Those are socio-economic rights. Yes. So socio-economic rights, example, right against discrimination. है ना, कोई कास्ट बेस्ड, रेस बेस्ड, जेंडर बेस्ड डिस्क्रिमिनेशन नहीं होना चाहिए. यस. इफ यू वांट यू कैन, है ना, ब्रीफली इफ यू वांट यू कैन मेंशन इट, अदरवाइज है जैसे भी यू आर कंफर्टेबल. आई एम नॉट गोइंग टू डिक्टेट इट लेटर ऑन, दैट इज द पॉइंट. है ना. देन यू हैव राइट टू फूड, राइट टू वर्क, राइट टू एजुकेशन. है ना. These are some examples of certain socio-economic rights. है ना. कुछ हमें इस तरह के rights चाहिए जिससे हम अपनी quality of life improve कर पाए. So we started demanding what is known as the second generation rights, which is socio-economic rights. Once we got these rights also, we realized there are certain more rights that we need to in fact lead our life to its fullest potential. Yes. So man started demanding third generation of rights. Yes. So these rights came to be known as solidarity rights. Yes. तो हमने कहा कि ठीक है, right to food, right to work, ये सब तो है, but we are human beings, we need right to clean environment. Yes. So you want certain rights, है ना. We need right to clean environment, to clean drinking water. Yes. We need right to preserve forests, है ना. तो इस तरह के जो हम rights demand करने लग गए, they came to be known as solidarity rights. Because these rights cannot be exercised by individuals. These rights can be exercised as collectives. When I say this is my right against climate change, can I individually get a climate which has not changed? It can be exercised only in solidarity. Right to clean environment, right to clean water, right to good sanitation, है ना. All these rights can be exercised only in solidarity. Right of tribals to forest ownership. Yes, and to the forest resources. They can be exercised not by one individual, but as collectives. And a right to preserve my language. Can I preserve my language on my own? I can be the only individual speaker who will speak my language. It will be preserved as a group. Fine. So you find that such rights, since they can be exercised only in solidarity with others, they are known as the third generation rights or solidarity rights. And these rights are often exercised at times as a limitation on first and second generation rights. For example, if tribals say we have right to the forest resources, then they can exercise it only in solidarity. But that means individual ownership of certain pieces of land on forest has to be banned. So my socio-economic rights, right to, you find that will be impacted. Yes. So these are solidarity rights which at times require or demand curtailment of first and second generation rights. And recently we have entered into fourth generation of rights. So today man is demanding what is known as the fourth generation rights. There has been a consensus about first, second, third. Ab man has started demanding fourth generation of rights. In context, what is the context? Technological development. Unprecedented technological development, artificial intelligence. Yes, genetic engineering. So my right to organic food which has not been genetically modified. नॉन जेनेटिकली मॉडिफाइड फूड इज माई राइट, है ना, टू प्रिजर्व, राइट टू प्राइवेसी, राइट टू सिक्योरिटी, साइबर सिक्योरिटी, है ना, ये सारे क्या है, फोर्थ जनरेशन राइट्स इन कंटेक्स्ट ऑफ the sudden technological development, scientific and technological development that we see in terms of genetic engineering, in terms of cyber, है ना, field, in terms of artificial intelligence. तो उस context में right to privacy, right to genetic integrity, right against cyber security threats are all examples of fourth generation rights. Fine. So you find that rights as such, human beings' conception of rights over the years have passed through phases. We have broadened our conception of right. We started with demand of civil and political rights. Then we started demanding socio-economic rights. Then came a time when we started demanding solidarity right, right to clean environment, clean water, right against climate change. And then came fourth generation right with respect to the great advancement in technology by men. Fine. So this is how rights have evolved, and this is the evolution of human rights as well as general rights. Fine. अब वही है, सिविल राइट्स का बिगिनिंग, सिविल एंड पॉलिटिकल राइट्स का बिगिनिंग कैन बी ट्रेस्ड टू, फॉर एग्जांपल, मैग्ना कार्टा. वी आर अवेयर ऑफ मैग्ना कार्टा, है ना. So you find that King John of England had recognized a charter of rights. This is the first document to put into writing the principle that the king and the government was not above the law. फिर वो एक बिल ऑफ राइट्स भी लेकर आए इंग्लैंड में. फिर फ्रेंच डिक्लेरेशन ऑफ ह्यूमन एंड सिटीजन राइट्स आया. फिर है ना, यूएस ब्रॉट अ बिल ऑफ राइट्स. The US Constitution initially did not have this Bill of Rights or fundamental rights. They were later on introduced through a constitutional amendment known as Bill of Rights. Fine. So they provided safeguard against introduction of taxes by the king without approval, arbitrary taxation के against, safeguard against arbitrary arrest, arbitrary confiscation of your assets, freedom of speech, freedom of thought, right to petition, है ना. So that is all. And in the modern age, such rights have found expression in these two documents. You have Universal Declaration of Human Rights and the International Pact on Civil Political Rights. Then came second generation socio-economic and cultural rights. We started demanding right to work, right to form association, right to education, है ना. ये सारे rights, and they have been expressed in International Covenant on Economic, Social and Cultural Rights, and they are known as positive law. Indian Constitution में civil political rights कहाँ recognized है? Fundamental rights में. और socio-economic rights कहाँ recognized है? DPSP में. ठीक है, they are positive in nature, that they ask the government to do something. है ना. पहला वाला जो राइट था वो कह रहे डिस्क्रिमिनेशन मत करो, है ना. जो है फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन मैन के पास हमेशा से था, तो वो रहने दो, उसको एब्रिज मत करो, उसको कर्टेल मत करो. लेकिन यहाँ पे राइट टू वर्क दो. द गवर्नमेंट हैज टू क्रिएट एम्प्लॉयमेंट, है ना. राइट टू एजुकेशन दो. द गवर्नमेंट हैज टू क्रिएट प्रोविजन वेयर ऑल ऑफ अस कैन गेट मिनिमम लेवल ऑफ एजुकेशन, ऑल सच थिंग्स. तो इसको बोलते हैं पॉजिटिव. व्हेन दे हैव टू डू समथिंग, द गवर्नमेंट इज एक्सपेक्टेड टू डू समथिंग. And the third generation rights is solidarity rights. Yes, right of the people to self-determination, right to peace, right to development, right to clean environment, clean drinking water, right of sexual minorities. तो अब sexual minorities है ना, LGBTQ community, they cannot exercise their right individually. As a community, they have to be given those rights. Yes, all this. Once again, they are a positive discrimination कहा जाता है. basically they put some restriction on first and second generation rights and fourth generation of human rights in context of ongoing technological advancements such as AI, genetic engineering, cyber field में, है ना, fast technological development. ऑल सच आर एग्जाम्पल्स ऑफ फोर्थ जनरेशन ह्यूमन राइट्स. ठीक है, तो बस आपको यही, यू शुड जस्ट नो फर्स्ट, सेकेंड, थर्ड, फोर्थ जनरेशन ऑफ ह्यूमन राइट्स. फाइन. नेक्स्ट इज importance of rights in a democratic society. Yes, what is the importance of rights in a democratic society? I think so it is already time then. We'll continue with the discussion on rights. We'll go into what are, है ना, बाकी concept of rights under India. इंडिया में कैसे कॉन्स्टिट्यूशनल, नॉन कॉन्स्टिट्यूशनल राइट्स जो हैं हमारे, फिर कॉन्स्टिट्यूशन में फंडामेंटल राइट्स पे हम विल हैव अ ब्रीफ डिस्कशन बिफोर मूविंग ऑन टू DPSP in tomorrow's class. Fine. Fine then. Thank you.